Intoxication defense with case examples. Hello and welcome back to Criminal Law Defenses Explained. In this episode, we would be looking into one of the most debated and complex defenses in criminal law, intoxication. We will cover how this defense operates, when it can be used, and how it affects criminal responsibility. And as always, we will highlight some famous case examples that illustrate how intoxication is applied in court. What is the intoxication defense? The defense of intoxication comes into play when a defendant claims that they were under the influence of alcohol or drugs at the time they committed a crime. It can potentially reduce or eliminate criminal liability, depending on the circumstances. However, this defense is limited in its application, and it is not a free pass for criminal behavior. In fact, courts treat it with great caution. Intoxication can be divided into two categories: voluntary intoxication and involuntary intoxication. The success of the defense depends on whether the intoxication was self-induced or accidental. We'll explore these two forms and see how they affect the outcome in criminal cases. Voluntary intoxication. Voluntary intoxication occurs when someone knowingly consumes drugs or alcohol. In most cases, this defense is limited to crimes of specific intent, where the prosecution needs to prove the defendant had a specific purpose or intention when committing the crime. For example, in R. v. Maevsky, 1977, the defendant, Maevsky, assaulted several people while intoxicated from a mix of alcohol and drugs. He argued that he was too intoxicated to form the necessary intent for the crime. However, the House of Lords rejected this defense, ruling that voluntary intoxication could not be used to avoid liability for crimes of basic intent, such as assault. The reasoning is that by choosing to become intoxicated, the defendant is responsible for their actions, even if their judgment is impaired. Involuntary intoxication. On the other hand, involuntary intoxication is a much stronger defense. This happens when someone is intoxicated without their knowledge or consent, such as when their drink is spiked, or they are forced to take drugs. One well-known case illustrating involuntary intoxication is R. v. Kingston, 1994. In this case, the defendant, Kingston, was drugged by a third party and then committed a sexual assault while under the influence of the drugs. He claimed that since the intoxication was involuntary, he should not be held responsible for his actions. However, the court disagreed, ruling that while his intoxication was involuntary, he still possessed the necessary intent to commit the crime. The defense of involuntary intoxication failed, as the court found that the defendant's underlying criminal intent was present. Intoxication and the distinction between crimes of specific and basic intent. It's important to understand that intoxication defenses are treated differently based on the type of crime. For specific intent crimes, where intent is crucial to the charge, like murder or theft, intoxication may be a valid defense if the defendant were so intoxicated that they could not form the necessary intent. However, for basic intent crimes, such as manslaughter or assault, intoxication will not work as a defense. The courts take the view that by choosing to become intoxicated, the defendant bears responsibility for any reckless behavior. In R. v. Lipman, 1970, the defendant, Lipman, consumed LSD and, while under the influence, killed his girlfriend, believing she was a snake. He was charged with manslaughter. Although the court accepted that he was severely intoxicated, they rejected the defense of voluntary intoxication because manslaughter is a crime of basic intent. The defendant's intoxication did not excuse his actions. The limits of the intoxication defense. The intoxication defense is not without its limits. Courts often view intoxicated behavior as reckless, and voluntary intoxication is usually not a valid defense for crimes of violence or recklessness. In addition, even if intoxication can negate specific intent, it doesn't guarantee acquittal, particularly if the defendant's conduct endangered others. Another case to consider is R. v. Heard, 2007, where the defendant was intoxicated and committed a sexual assault. He argued that he was too drunk to form the intent to commit the crime. However, the court dismissed his argument, ruling that sexual assault is a crime of basic intent, and voluntary intoxication did not excuse his conduct. In summary, the intoxication defense is a tricky one. Voluntary intoxication rarely absolves someone of responsibility, especially for crimes of basic intent. Involuntary intoxication, on the other hand, can be a valid defense, but it is not guaranteed to succeed, as we saw in Kingston. Intoxication may reduce criminal liability in some situations, but courts are careful to ensure that it doesn't become an easy escape route for reckless behavior. Thanks for joining us today on Criminal Law Defenses Explained. Be sure to like, subscribe, and hit the notification bell to stay updated on our next episode, where we will discuss another key criminal law defense: insanity. If you have any questions or case examples you would like to hear more about, drop them in the comments below.